Hi, I'm Jordan Isringhouse, Chief Legal Officer at Swift Law North. I'm here today with Swift Law North CEO Aaron Swift. Hi, Aaron.
Thanks, Jordan.
So today, one of the topics that we want to talk about are really important definitions under the FDCPA, some of the kind of general legal standards. So what are kind of some of the first definitions that kind of come to your mind that consumers and some of our affiliates should be aware of?
Well, I'm not sure you did that on purpose, but consumer, which was in your last sentence, is the very first important one. And it sounds probably simple for the audience and maybe some of our partners, but it's not actually simple in practice. So to qualify to have claims under the statute of the FDCPA, it has to be a consumer, which is a natural person. Just think of a human being, someone who's alive, which means you cannot use this statute as a business or as a entity, for example. So that's why it's important to be a natural person, like an HOA, for example, couldn't sue on behalf of itself because it's not a consumer. So that's the first thing. It's a natural person. Then that natural person has to either owe a debt or be alleged to owe a debt. And that second part's very important. And that just means someone's trying to get money from you, right? That's the whole purpose of the statute, is to regulate the debt collection industry and to protect consumers. So you have to have a consumer, a natural person, and they have to either owe a debt or be alleged to owe a debt.
So who's the someone though that you're referencing that was trying to get the debt? Who under the law? Who's the
great
someone?
question. And that's a debt collector. This is one of the critical distinctions and most important lessons in this entire video introductory series on the FDCPA is that this law only covers third-party debt collectors. You're going to hear that a lot throughout this lecture series, but it's very important to understand that that doesn't cover first-party creditors. That's usually the people that you've contracted with. So, for example, if I have a Capital One card, they're my creditor as a first party. If they try to collect from me, that's not a case because they are not a debt collector. It has to be a third party. Another way to think of that, if you don't mind me keep going on the debt collector definition, is the other analysis to look at is when did that person get the debt? And usually it's after the debt is in default. That's another distinction you can draw. The creditor usually has the debt before it's in default. And then if it's turned over to a third party after default and that debt is in default, that kind of helps tie the whole thing together. So it's consumer and it has to be a debt collector, third party to be covered.
Okay, so what kind of in that setup, in that arrangement, what kind of conduct are we talking about? Like what should we be looking for in terms of that interaction between those two parties?
That's a great question. So to again kind of tie the whole circle of the communications and how this works is there must lastly be a communication that violates certain prohibited practices. So you start with a consumer, natural person who owes a debt or alleged to be owed a debt. They have to be contacted by a debt collector, not a first party creditor. And there has to be a communication from that debt collector to the consumer, which can be either directly or indirectly, which is also an important distinction. And then lastly, I guess I'd just say it has to be then a debt, which is also a consumer debt. So that would be the fourth and last of the most important definitions to kind of, again, complete the circle is the consumer is being contacted, the natural person who owes a debt or is alleged to be owing a debt by a debt collector, a third party. That debt has to be a consumer debt used for household or family purposes, and there has to be communication. So it could be a phone call, a text message. It could be communication through your neighbor. It could be communication through your secretary at work. So even if someone called your office and left a private message to you that says you owe money, they didn't communicate to you, right? So you'd think maybe they're not protected, but that communication is protected under the statute because it's an indirect way to get to the consumer.
Okay, so those are some of the definitions.
Yes.
Okay, and I think we've kind of defined some of the parties, their roles, and how they're interacting. Is it as simple as we just fill in those blocks, like we fill in who the parties are, what they're doing, or how do we take it further? How do we figure out if we have a potential case or if there's a problem?
Yeah, great question. So to put it in kind of more context, we're talking about the definitions that the statute lays out. It's Florida statute, it's 15 USC United States Code 1692A starts the definition section. So you can even read these if you'd like. That's where you have to start. Any legal analysis, any potential claim, anytime we're approached as lawyers to issue spot a fact pattern, you just have to decide first who's at play and what statute, and you go to the definitions. The next thing you do is you talk about what are the legal standards. Is that kind of where you're going, I think?
Yeah, yeah. Standards for applying these definitions we just talked about.
Right.
How do we get there?
Okay. So I'm going to talk about two important standards under this law that our audience needs to keep in mind, whether it's consumers, credit professionals. One is that the FDCPA is called a strict liability statute. And put simply, that means you don't even have to intend to break this law to actually be held accountable for it. So let's say, for example, one of the things we're going to talk about in a bit, and in this lecture series, is common violations by debt collectors. One of them is you call someone after 9 p.m. to collect the debt. You can't do that. What if someone moved from the central time zone to eastern time zone and the debt collector didn't know? But now the time zones are off, so they call them thinking it's still before 9 p.m., but it's not. It doesn't matter. The statute says it's a strict liability. There's no purpose or intent. In law school, we learn about something called mens rea. Your mental state when you violate something. It doesn't matter here. Debt collectors who don't follow the law, even if they inadvertently break a part of the statute, they are strictly held liable.
Okay. And so when we're talking about, we've got the players, we've got the standard, I guess, in terms of breaking it and everything. So how could a consumer, like, I guess, from whose view is it that the law is broken, or that something's maybe deceptive or something like that?
Right.
How does the court, or really under the statute, how does that determine?
Yeah, it's a great question too. So if you put the debt collection industry into context, you have to think about whom are the players owing debt, and we have to protect them. So that's the whole purpose of the statute. It was passed by Congress to protect consumers against unscrupulous debt collectors. But not every consumer is the same. We all have our different skill sets, our intellectual abilities, and this law has to protect the vulnerable people who may or may not owe a debt. So what the courts have decided is they apply a standard called the least sophisticated consumer. And so when you're looking at conduct or a communication, as we talked about before as part of the definition, you're not looking at it through the lens of would a normal person understand this letter or be harassed by it? Would a very sophisticated person? What you look at it through the lens of would the least sophisticated consumer be able to understand this, feel threatened, feel harassed? And the conduct is viewed through that lens. So even if they didn't try to break the statute, and even if they sent a letter to a Supreme Court justice who clearly knows a lot about the law, but there was something in that letter that was deceptive to the least sophisticated consumer, that's still a violation.
Okay. So all of that, taking all that in context, how does that, in your opinion, relate to the larger picture of credit repair organizations, credit reporting, just debt in general? How do you tie that all that together?
Yeah, it's a good question. So to put it into context of our video series, we understand our audience is either coming to us, they're a credit professional, they're an industry insider, maybe they're a consumer, though we have a lecture series for consumers as well. To gain access to any of these protections, you have to understand who they apply to or what they apply to. Like, for example, if a consumer comes to a professional and says, I'm being harassed for this debt and it's my business debt, you have to understand that distinction. And it's important to not mislead that person or a potential client to say, well, there are these protections that would apply to you. So that's one way. Another way is to understand what the touch points are, how you can protect yourself. And so if you understand these definitions, if you can really understand and apply these legal standards, it's going to help identifying these claims to then connect with lawyers like us at Swift Law North, because these cases that come from it can get to the same goal. You can use these cases as leverage to either negotiate debt forgiveness. Of course, if they're collecting a debt that's not owed, it gets that to stop. But you have to start at the basics. And these definitions and these legal standards are what must first be viewed. They all have to apply, and then you move forward to talk about the next part of the case.
Okay, well, thanks, Aaron. I think you've given us a good, detailed introduction to some of the legal standards that apply for the FDCPA. If you have any questions, reach out to Swift Law North, our CEO, Aaron Swift, CLO, Jordan Isringhouse at Swift Law North. Also, continue to watch the videos in this series and continue to participate in the Scholar Chats. We'll see you in the next video. Thanks.
Thanks.